Welcome to another podcast episode by your man, Oliver Adams. Most people call me the coach. This podcast on Talk Your Truth Thursday is an oldie but goodie. In the month of August 2023, I had three special guests with me at the Metro Brokers Cascade office off in the Cascade area. So let me introduce to you the individuals that participated in the subject of probate. Now listen, this is super important because it's for every family member. We had the Honorable Kenya Johnson from the Fulton County Probate, which is an active judge. We have Mr. Scott Baker from the Raymer Law Group, who is an attorney that deals on the real estate matters. And then we have Ms. Nicola Robinson from the SRB Law Group. So these three individuals was having a long discussion about the ins and outs in probate. The reason why I'm segueing this is because during that event, it got so good, the first 15 minutes we kind of missed. So I mic'd up the judge and I mic'd up Nicola, and we went and started from there. So I want you to go ahead and enjoy yourself. If you like it, subscribe, and please pass this on to your family, your loved ones, and everybody else, because this is the ins and outs of probate.
Low cost options available for a real estate agent to do it. And now we have the platinum plan, you know.
Yes, I like it.
But, but you guys can put a credit card down on this cooperative site, and you have access to lien records, real estate records, going back pretty far now. Now, those of you like Derek Whitner that are in Cobb County, the Superior Court in Cobb County, their website's even better.
Yes, I like
and their probate website. I mean, my gosh, Judge, it's awesome. But, this judge is going to be awesome. But let me tell you, that deed is the first step. Now the other thing I'm going to ask. Let's say we're not dealing with a joint tenancy situation. I want to know whether they had a will or not. There's kind of two streams here.
Yes.
The judge and Nicole will talk about this. There's people that have a will, and that's a testate situation. It's Latin for having a will. And there's people who don't have wills. They call that intestate. Now, if you don't have a will, your property is going to be distributed according to the laws of descent and distribution. And it's a pretty logical system. There's one set of rules for someone that died before 1997. There's another set of rules for people that died after 1997. But it gives percentages to people in the family. And just so you'll know, usually a wife gets a share, children get a share, and then it splits it up amongst the family as you would think. Okay? Now, where I come in as a title practitioner, the law says that property vests in these heirs when there's no will, subject to administration. What the heck does that mean?
That's where you come back to me.
Okay. So the heirs actually own that property. But by going through a process of administration, you kind of change the game. Okay? Now, from your standpoint, if you don't go through that administration as a listing agent, those heirs, remember what I say, they own the property subject to administration. So if you got that family coming to you to list the property, all the liens and judgments against those kids, they attach to that property. If you don't go through everybody,
Probate.
go through the judge. Okay? So this makes a great difference to your business. If you have that situation, people don't have wills. We've listened to the judge encourage us to all have wills or an estate plan trust. Go to Ms. Robinson. But if you don't, and it ends up in these heirs, they're going to have liens against them. I'm going to tell you as I present, there are times where you do not have to go through administration because I said it's in the name of the heirs. Now, my title insurance companies and the title standards of Georgia say if someone's been dead less than 4 years, they have to go see Judge Johnson. If they've been dead more than 4 years, I can put into the record through affidavits, usually two unrelated folks, and say, these are the heirs, but remember, I got to make sure those heirs don't have any liens against them. I have gone down the path, Oliver, and well, we don't want to go to probate. We don't want to hire Ms. Robinson and go to Judge Johnson.
Okay.
We've been dead 5 years. We're going to go ahead and take these affidavits. I want to take door number 2. And then we go to start checking down those heirs, and they all got liens against them. Oh no, we're going to see Nicola.
And you have
I'm
to.
gonna kick it to you in a second. But I don't think you might have missed something. The heirs got credit card debt, I'm assuming, right?
They got their own right.
Everybody's got a nephew, right? So nephew have an administrative right if it's not clear. And when they begin to process that piece, nephew with debts attached to the property as well?
Nicole, I'll let you take it from here. How does administration help?
So administration identifies all the heirs. We find nephew because a lot of times, let's say Bob died. I'm gonna keep killing off Bob. Bob died, and then we have to, right? No Bobs. Bob died. He had maybe 2 previous older kids, but one of those kids died, and they left some kids. And so now we are trying to figure out, okay, well, who are all of the heirs of Bob? So we have to even sort for that. And I get a lot of times people will come in and they'll say, oh yeah, Bob died, Bob's son Kevin died, but we don't talk to the wife. But he was married, so she is now entitled to his share. Or maybe they had some kids who are now incarcerated or homeless. So all of these people have to be accounted for because, as he said, when Bob died, they are now considered part of the people who own that property.
So I want to take a moment to step back about what we do in probate and exactly what is probate. So probate is when you open an estate for a deceased person. And the end goal of probate is to get what's called letters testamentary. And that is the piece of paper that gives the executor or the administrator the right to go to the bank and ask questions and call the mortgage company and to even sell the property. So someone passes away with or without a will. If they have a will, they can designate who's going to be their executor, who are their beneficiaries, and they can even put in the will whether the person they select to be the manager of the estate, that's the executor, that they have to get permission to sell the house, or they can put in the will this person doesn't need any permission. They don't have to account to the other beneficiaries. They're able to act with impunity. But if someone passes away without a will, then their property goes intestate succession. So probate court is the process of opening an estate, notifying all the heirs that an estate has been opened, notifying the world via publication in the newspaper that someone has passed away. So hear ye, all creditors to this estate come forward in the next 30 days. And then at that point, debts have to be paid, assets assembled, and then distributions made to the heirs. If there are no debts, then you can go forward and distribute the estate. The benefit of a trust is that a trust doesn't have to go through probate. So it's almost like if you have a retirement plan or a life insurance policy and you list a beneficiary, that money goes to them as soon as you pass away. As soon as they show your death certificate to the life insurance company, they're going to get a check. Well, with a trust is just like a will, except for one can be handled outside of probate and one has to go through probate. So once your executor or your administrator, if you don't have a will, they're the same thing, so we may use those terms interchangeably, but that's the manager of the estate. They still have to follow what's in your will, or they have to follow Georgia law for intestate succession. Specifically, so everyone will know, if you pass away without a will, your property goes to your spouse and your children in equal shares. However, the spouse never gets less than 1/3. So the remaining children share the 2/3. Georgia law favors taking care of your spouse. Amen? So the spouse never gets less than 1/3, and the remaining children, be it 1 or 10, get the remaining 2/3. What if you don't have a spouse? Everything goes to your children in equal shares. The Georgia law favors blood relationships. So half brothers and sisters take the same as full brothers and sisters. No difference there. If you don't have a spouse, it goes to your children. If you don't have children, it goes to your parents. If you don't have any parents, it goes to your brothers and sisters. And on down the line until we can find a blood relative. Georgia law has what's called a laughing heir statute. We will continue to look for a blood relationship. We may have to go 10 degrees, and this person may not have ever met you, but they're going to be laughing all the way to the bank because they were your only living relative. So it's all about looking at the will or going according to Georgia law. And once your executor files that paperwork, all the heirs have received notice, all the creditors have had a chance to submit everything, and now the manager of your estate gets those letters testamentary, which again allows them to handle the business and begin making the distributions.
You want to? Okay, because she brought up a bunch of stuff.
The judge brought up some things I want to.
So I want to talk about creditors and debt, because I think people, and we just had this conversation, a lot of times people don't understand those debts have to be paid. We have to deal with that. And so when somebody's calling you as the realtor saying they want to sell this property because we want to share up this money and we want to all go to Hawaii, you got to remind them, like, no, we have to go through this process. Even if that property is sold, depending on what debts have been left behind, that money may need to be used to pay and settle those debts. It may or may not be anything left for the family members. And sometimes that's a hard pill for the family to swallow, because they're like, but mama said I was going to get the house. Well, mama left $100,000 to Amex. She left IRS $200,000. And so that has to be dealt with. I see it all the time where people come in and say, oh, I thought that went with them to the grave. No.
Or a reverse mortgage.
Or a reverse mortgage. Maybe mom took out a reverse mortgage while she was still alive. And so all of that has to be looked at on the front end, because you don't want to get in front of Judge Johnson and it's like, ta-da, here's all these creditors with their hands out and they want their money.
Okay, now another thing Judge mentioned, I want to reiterate, she's talking about this, how Georgia favors the blood relation. Okay, I've had the situation over the years where people don't recognize those out of wedlock brothers and sisters.
They count.
They are heirs.
They count.
Okay, word to the wise. They will be cut out on your listing,
And
but
so
they get to cut them in.
Yes, you want to ask those questions, because just because they're estranged from that person, or they don't talk to them, like I said in my first example, they don't talk to that wife, but she's still the wife. Judge just told you, we favor wives, we favor spouses by law. So just because they don't talk to them or they're estranged, it comes up all the time where they're just like, oh yeah, we ain't talked to him in 10 years. But he's still an heir. He still gets notice. He still gets his opportunity to come and figure out what portion of this estate, if any, is going to be his.
So who's from up north? And somebody died. The family member that's in the house with the death of the parent or the relative, they tend to take all the documents, hide them. Am I the only one that drove?
I think that's in the north.
That's out everywhere.
They don't tell nobody nothing. It still makes it through probate. Son, daughter, nobody gets nothing but that one person. How do they get away with that?
So let's talk about this. Probate records are public records. So once an estate has been opened and they're seeking permission to sell the house, then anyone that requested can come up and get copies. Probate records, what am I trying to say? Everybody can, you can get access. I lost my train of thought. It's a senior moment. But the way that you file probate is it's in the county where the property is or where the person passed away. So those are the only two places that you would go looking for an open estate. The county in which they passed away or the county where they held property are both places where they can open up an estate. So if you have someone that says, you know, I know I have a piece of a property, but they're not talking to me, I don't know what's happening, you can send them to the probate court in either of those two counties to look for the estate so that they can then get the records and see what's going on. But they should have been listed in the initial documents, and oftentimes that's another trick that some people may use. Don't list everybody. Just don't list everyone, because I'm only going to list the people that's going to sign off on me being in charge and me handling everything. And so people come up all the time, and that's called when you file an objection to someone being the manager. then that's called a caveat or an objection. And so now we have a legal fight because we've got one person that's saying she shouldn't be in charge. She's a drunk. She had, all kind of things that they come up with to try to prove to the court while this person shouldn't be the manager of the estate. And so now that's when we have to have a hearing, and it's up to the court to determine who is which brother should control everything. It doesn't change who should get what. It's just who is in control of writing the checks to who it goes. People think it means, well, if this brother's in charge, they're not going to give me what I should have, which could be true, but all the court is determining is who should be in charge. And when the court can't figure out who should be in charge, because trust me, they're throwing allegations all day in court why I should be in charge and he should not be in charge, then the court always has the ability to appoint what's called a county administrator. This is a third-party law firm, completely neutral, that will only follow the law. They have no dog in the fight. They don't care their job is simply to corral the assets, pay the debts, and make the distributions. And that is very comforting to some families that just can't get on the same page, and it's uncomfortable for families that want to continue battling each other and want to be determined who's the right person.
There's some questions out there. One second. I had her first, then I'll go to you. Go ahead.
I have two questions. One about the will, because I'm going through this now. My parents, we thought, had a will, but when we took it to probate, it was told to us that the will was only for my mother. But both names were on there because it was Maggie and James. So how did they determine that the will was just my mother?
Judge, you want to?
I would simply say that it's not a practice nowadays to do joint wills, but years ago, sometimes there were joint wills. And so it's just a matter of reading through all the provisions of that will and seeing what applies to whose wishes.
Okay. The second part, supposedly my father had some kids before he got married.
Rolling stuff.
Oh, I love those. Those are my favorite.
My sister, it's 5 of us, so everybody was like, put them down as special recognition on the obituary because my father passed last. So at that point, the probate court says, well, your father doesn't have a will. And we was like, no, it's a joint will. But she says, no, he didn't have a will. Long story short, she put them down on the obituary as siblings. So, with that being said, now it's 7 of us that they're saying that are siblings, that we all had to give my sister the administrative rights. Now,
What's the question?
the question is, the sibling who all of this time when we put one name on there that we thought was her name, when we had to get legal documentation, her name is something else. Who? Is she still considered a sibling?
She is always considered
been a sibling.
She will be a sibling. And I have something for you to consider. Mom may have passed away and give everything to her pieces of everything she had to father. And now father passes away, so some of mama's property might go to those children that aren't of the union. So that's why it's important to have a will to make those determinations, and imagine how it feels when you have to share a property with someone you just found out about.
And
So
a lot of
that's what
times,
happens.
I'll say this. Yeah, I was going to say, a lot of times we ask for DNA testing in those situations. I've had where people stop, jump up at the funeral and say he was my daddy too. Not a problem. We will put them on that petition, and then we will ask the court to order DNA testing to make that determination. Because remember, again, we have to figure out, get it out of that person's name to the right individuals. And so DNA testing might be the only way we can figure out who the correct individuals are that are entitled to inherit from this person.
Outstanding. Good question. Okay.
Okay, hi.
Without the, you can't read that.
Not even a little bit.
But listen, I'm working with executor on a estate that I have under contract. And my question is, underneath the letters of testamentary, it says relieved of following returns. What does that mean?
So the law builds in where executors or managers have to be accountable to the heirs because of that mistrust and doubt. So what have you done with the property? In the will, you can put in there that this particular executor doesn't have to account to everyone else, or you can say that they do. If you pass away without a will, then the court requires within 6 months of opening the estate, they have to file what's called an inventory. You have to tell all the beneficiaries what you found in the estate. And if you've made distributions, you need to put that on a return and submit that to the court so that everything is above board and all the heirs get to see who got what and in right distribution according to law. And if they have a problem with that, they can always come to court and contest and say he got 50% when he only was deserving of 30% and I want my money.
Okay.
Just dovetail what the judge said. Guys, when you're drafting your own wills, you can excuse your executor of duties like filing annual returns by simply putting that in your will. And this is where Nicola's going to help you.
And you may or may not want to, depending on the people that you know are related to you and will be the ones left in charge. So if you think there is going to be some conflict between your children, you may say, you know what, I want them to do inventory because I want everything to be above board, like Judge Johnson said, so that way all of the siblings can see for themselves what was in the estate, how was it handled, and that way they don't have any question or confusion about it. Now, if you have maybe one child and there's nobody that they really need to account to or answer to, then you might just say, you know what, we waive that. I don't want them to necessarily have to file anything with the court. I want them to just be able to go through the probate process, clean up everything, and then close it out.
And as you engage in your own estate planning, I encourage you to consider to be the manager of your estate, your most responsible child, not the one who you love the most or your firstborn, but the one who can handle the business. And another source of dissension is there may be a will, and mother will have detailed the will, but in the later years it may have been another sibling that was caring for the parent, and or certain promises were made bedside. You know, you've been here for the last couple of years and, you know, I'm going to give you the house. But if they didn't write it down, then when you look at the will that was made 10 years ago in better times, it may have given someone else control. And so that creates a lot of dissension, and people can file objections to actually override the will. And there are several reasons that you can sort of object to a will. Children put a piece of paper in front of mom's face. She doesn't have her glasses on. She was sick. She just signs it. You can, so that's fraud or undue influence, or the caretaker who's there every day. They have the food in front of them, but I need for you to sign this document first before you eat dinner. That's also undue influence. So there's several reasons why you can even contest a will, even if you engage in estate planning. And all of those are things that come before my court every day. And families in crisis, because their communication, they don't trust each other, or they just are unsure of why mom made this decision to put sister in charge when I'm the one that's been there every day.
So Coach, in my career, I have found it's a matter of perspective. The good sister considers herself the good sister, and the other sister's the bad sister. Bad sister considers the good sister the bad sister. That is a maxim.
I got Miss Bobby got a question. The hands are coming up. That's cool. Right? So I got Miss Bobby first. Go
Okay,
ahead.
I have 2 minor grandchildren. They don't have a mother. They live with their father. So I do have my health directive in place.
What is that? A health directive.
So in Georgia, you used to hear people talk about, I got a living will. We have not had a living will in God knows how long. What we have done instead is create what's called the Georgia Advanced Healthcare Directive. And that allows you to name the person that you would want to make medical decisions for you in the event that you can no longer do so. No, it's just for healthcare purposes.
Okay, they live with their father. So if I should pass away, does he get anything?
Is their father your child?
No.
You said that.
So so you have two minor, let me make sure I understand, two minor grandchildren. If something were to happen to you, then let's say you want everything to go to these minor grandchildren. Because they are minors, we're going to end up right back in probate court. We're going to need to do either a conservatorship, assuming you left, let's say, a house and some bank accounts. Because they are minors, they can't necessarily inherit those things outright. And so we're going to go back in front of Judge Johnson, and we're going to have the courts appoint somebody as a conservator that's going to manage those things for those children until they turn the age of 18, and then it's turned over to them as at 18. Now, a lot of times my estate clients take issue with that because they're like, well, it's $1 million at 18. They're going to have nothing by 19 because they went to Vegas. And so if you are concerned about things like that, their maturity at the time that they're going to inherit, then you may not want to go the conservator route. You may want to do your estate plan properly, a trust, for example, which would then be able to say when those things would be distributed to those children. Maybe you wanted to go to them at 25 or 30 when you think they're a little bit more mature and can handle it. So if you are concerned about these minor children inheriting things, you really need to sit down and do your estate plan.
So the son-in-law does not get anything.
No. But he may. I'll say this: he may be the one that goes to probate court and asks to be the conservator. He might be the one managing everything that you left of those kids.
And also, I want to encourage you, as you engage in estate planning, let your family know where your documents are.
Yes.
You know, Aretha Franklin, they found her will in the seat cushion of the couch. And there were other people. James Brown didn't have a will. Prince, the artist, didn't have a will. So be sure to let people know where your documents are so that they can access them when something happens.
1 second, I got Maggie. Hey, listen, if y'all gonna raise your hand for a question, 1 second, I got Maggie first and I'm coming up here. If y'all gonna raise your hand for a question and I come back to you and you texting, I'm gonna just skip you. Oh, wow. Maggie, come on.
I have two questions.
Can we get with the one question stuff?
Right.
Okay, I heard you say they need to put it in the newspaper for 30 days. Now, suppose they don't know that they owe taxes on anything, and you put it in the paper for 30 days, but that doesn't come up.
Let me tell you who know more than anybody else. The IRS. The IRS, the minute those, because as part of the probate, the business of handling somebody's estate, is you have to put people on notice. So you got to tell Social Security that the person has died. You got to notify the IRS. You got to file their last taxes. If they drop dead in March, they earn money January and February and part of March. So we got to also have all of that taken into consideration. And so trust me, the IRS will know.
And I want to add to your question, if a creditor's claim comes in after 30 days, the court does not have to consider it. So there are companies, credit card companies have systems and people that are constantly scouring. The way that we do notice is through the Fulton County Daily Report, which is a sort of legal trade paper that usually many people don't look at other than lawyers, but they have search programs that when names of people that owe money come up in any newsprint, like a Google alert or something, then they're able to file the paperwork. But if it comes in after the 30 days, we don't have to count it.
And the credit card companies, like she said, that's the people's whole job is to figure out who died. So a lot of times I'll just file the petition for probate the very next day. Here come Amex. They call me because they're looking for those names. They're searching the public records every single day.
What's the contact information for the credit card folks? Because that's what we all need to connect with, right? It's 1 day turnaround. You had the second part of that question real quick, then I'm coming here.
Okay, now, this scenario, a man died. He had
Bob.
two families. Okay, but the family that he lived with wasn't the woman that he married. She had 3 kids with him. Okay, now, the mother dies, and so the sisters asked the first family daughter, did she want to take care of him? And she said yes. Before, she didn't want anything to do with him, but because that mother took him, because he had found out he had Alzheimer's, he had prostate cancer, so they asked her, did she want to take him to the doctor? She said no. You know, he brought all this on himself, so they kind of ignored her. But then after she found out he had money, then she wanted to take care of him. Fast forward, he dies. notifies none of the kids about anything, what could be done about that? And is there a limitation on the number of years that they can go back and file something against her?
So was make sure I understand, the second person that took care of him was not his wife. He did not marry her.
It was his daughter.
Okay, it was his
He
daughter.
had 5, 6 kids. He had 6 kids, but only the 2 on that sister and another sister only got anything that he had. The other 4 didn't get anything.
Did he hold
Because
real
she said-
estate, Maggie?
No, he didn't. He didn't. It was just money in his account. Because I knew.
Yeah, money is
I knew
liquid.
he had money
Yeah.
in the account. I wasn't his daughter, but my mother trusted me with him. So I just turned it over to his oldest daughter. But the other 4 didn't get anything. So
Well, just to remind you that the law favors spouses and blood relations.
Yeah.
So you can never, you can waive that inheritance, but you can never lose that because that's your blood relative. So whenever you show up, that your money should have been held to the side. So say if you do sell a house, but you've got a family member who is entitled to inherit, but you just can't, you just don't know where they are, or maybe you just can't reach them, or they're not talking to the rest of the family. Well, their money needs to be put to the side because whenever they come back around, they are entitled to their portion of the estate.
Who they sue?
You may have heard about a bond. So when someone passes away without a will, probate court requires them to put up a bond, which essentially is an insurance policy saying you're not going to steal from the other beneficiaries. And if it comes out that you did steal from the beneficiaries, then the bond will pay what's due. But if you have a will, you can say, my family doesn't have to pay a bond. But that is one benefit of if you don't have a will, is that everyone is required to have a bond and to account to the court.
So the only thing he had was money.
So it sounds like in your scenario, he didn't have a will, he just had a bunch of money in the bank accounts, and one of the children took the money. And one of the children took the money, and they kept it, and they benefited, and they didn't go through the probate process. So they have defrauded the other ones. They have stolen the money from the
That's
other
called a
ones.
felony.
That's a crime, and that's what the only recourse they have at that point is to either press criminal charges or to go that route in terms of. But honestly, in my experience, when it's cash, it's gone. It's just gone.
But if it's in his bank account, though, you can prove it.
If it was.
Oh, it was in it.
But at some point, he had to have that person listed as the beneficiary payment on death. Otherwise, you have to come through probate court and
get
get
it
the
out.
letters testamentary to even get in the bank account. Or if you're listed as payable on death, you will get that money. You're co-owner of that bank account, and you get it when they pass.
Real quick,
Maggie?
So let me give some more ground rules real quick. The good news is we got a lot of time. All right? The questions are beginning to get stimulated. Folks want to get involved. I got a couple of hands here. But do me a favor. Can we have that one question so we can share a little bit as opposed to that follow-up to the follow-up? It's like the judge. They need to go see the judge. Money's gone, though. I ain't much going to lie.
It's gone, baby.
That money's gone. So I got right here first. Go ahead.
Question about common law. I just found out recently common law is, Georgia does not recognize it since, what, 97?
They abolished it.
Question,
97.
if someone was common law since 1980, are they like grandfathered
Still
in or
recognized as a
something?
marriage, yeah.
Yeah. So from 80 to 97, anything pre-97, if they held themselves out as common law, if other people saw them as common law, they believed themselves to be married, they signed documents as husband and wife, anything along those lines. If it was pre-97, it will be still recognized. Post-97, it's a no-go. And we see a lot of times people will be together 20, 30, 40 years, and then Bob dies. And and she comes to me and she's like, well, don't I get anything? I was the common law wife. And it's really heartbreaking to be like, no.
Now, Nicole, I think you probably have to show proof that you were holding yourself out as husband and wife prior to the abolition
Yes.
of common law.
You do,
Yes,
and that
and
would be
that's
for
what
the
I
court to determine.
Yes.
If a family
Have some
member,
evidence.
if a family member objected to that and said no, she was just the side piece. He had a real
Yes.
something over here. Then that would be that then that would be for the court to decide whether he really held out, and they may have to call in some witnesses, some
Yeah.
friends to
I
say,
think it requires consummation as well. Right?
Yes, it's old law. But there is nothing worse than he's been with this person for 20 years, but guess what? He never did divorce that high school sweetheart, who is still his legal wife. And so she, again, remember Judge Johnson says the law favors spouse. And so we have to have those hard conversations in my office where I'm like, I know you took care of him through dementia and the hard times and this, that, and other. But the first wife that he never divorced is the one that's going to end up with almost all of this.
Oh, like, God bless you now.
we've even seen situations where people don't change their life insurance policies.
Oh, that's very common.
And you've remarried someone else, and now the ex-wife gets everything.
Yeah, that's really common.
I gotta fix that.
Or the house, or the house is still titled in the ex-wife's name.
Joint tenants
jointly
with
in
a
the
right of
ex-wife.
survivorship.
So real quick, I see them, we going this way, right? Because at first, I'm thinking, I'm like, oh, hold on now, I was dating for 20 years. Just got married, just got off a honeymoon. I could have fell in that situation.
Yes, yes, yes.
So
yes.
now before I get on the next plane flight, I'm gonna have a clear wheel.
And this is what I tell people, estate planning and doing this type of planning is not a one and done. You don't just do this, throw it in the drawer, and then say, oh, I got my will done. I mean, I did it in 97, but I got a will. No, it is a snapshot in time. So today, you might want those people to inherit from you. Today, you might want them to get your bank accounts. That doesn't mean 3 years from now that you feel the same way, or 10 years from now. Some of those people may have already predeceased you. Some of them you don't talk to anymore. And some of them you just be like, they are terrible with money. And I know that having put them in charge, they would not be a good steward of what I've left them. So you always want, your documents should be evolving. Every 3 to 5 years, we should look at them. We should decide, okay, am I still good with what we have here on paper? If not, what changes need to be made?
And also I want to take this moment. Is there anyone in the room that is a part of an organization such as a church or a sorority or a social group? Many of us have organizations that we are part of. Think about those organizations when you're no longer here. That's philanthropic and legacy creation. You may be paying dues to a chapter of the NAACP, but when you're no longer there, they don't have your income to keep with their operations. And so we're embarking on a program this fall called the 5% program. And we're asking that you take a look at your life insurance policies and think about leaving 5% of whatever that is to an organization that you love, be it your church, be it your HBCU, be it the Douglas High School class of 1974, whatever you love,
Astro.
support those organizations. Your family will still get the other 95%, but just remember, and that's how you live a lasting legacy so that your causes can still be supported.
Now, public service announcement brought to you by. Go ahead, what you got?
You guys, all the information that you're saying is great. I have a situation now with my mother. It's a good situation, just my sister and I, and her will. But I'm thinking about myself. Y'all, I don't have any children. I've never been married. My sister doesn't have any children, never been married. So we've said that the two of us, whoever is left, will get the other stuff, and we've told them what to do. And we do need to I know I need to update mine. She still hadn't put hers in writing yet, because I've realized that whom I had left some stuff to, in addition to my sister, it ain't gonna work. But the thing is, though, you all are talking a lot about people who have children. What about people with no children, like me, never been married?
So those are some of my favorite clients, honestly, because we get to do much more creative stuff with their estate planning. We get to do some charitable giving, like the judge just mentioned, sororities that you support, colleges that you support, different causes that are important to you. We get to work all of that into your estate plan. And you're like, okay, I want to give to Howard, or I want to give to, see, I just guessed. Or you can set up foundations and you want to do a scholarship. Like, we can do all of that if there is a desire to do that kind of stuff.
That's what I want to do.
Okay, but she
pick
she
someone.
knows. Let me
Pick
tell y'all
someone,
something.
or
Let me tell you something about she knows. Those are like those words make my flesh crawl, because she knows today. Tomorrow she gets hit by a bus. 2 days from now she gets Alzheimer's. We don't have a crystal ball, so we have no idea, are those people going to be able to do the things she knows that you would like for her to do? So the best thing to do is to write it down.
You write it down, then if that person, if she precedes me, God forbid, in death,
But when we do estate planning, we don't want to list just one person.
Okay, that's
we
can
always
list it
want
back
to
up.
list a successor, whether it be through a trust or through a will. We want to have a successor agent that's listed, because sometimes, God forbid, suppose she's in jail. She's not dead, but she's not available to do the work that needs to be done. And so we want to make sure we have other people that we can say are backups.
and designate. I was going to say designate someone, because remember I told you Georgia has a laughing ear statue, and we will continue to look for a blood relation, and it may be someone that you
Totally don't want it to be.
I just list them, say I don't want them.
You can specifically in a will, you can put in there, I am excluding X, Y, and Z.
Do like Miss Bobby do. No.
No.
Notice I got you coming out. Notice I moved over here because Attorney Nicola killing everything over there. You dying? I was like, you know what? This morning's affirmation. Stay away from that. Move on this side. So, yes, ma'am. Right there.
I'd just like to say I thank you all for being here. I had planned to come down last week, but all that fiasco was going on at the courthouse. And I'm glad you all are here today. Hopefully you can answer my question. So I'm a conservator of my niece. It's my nephew's daughter. And shortly after, she lost her mother when she was 5 years old. And she's about to turn 18. But shortly after I became conservator, her grandmother sued for custody, and her grandmother has custody of her. But her grandmother is kind of evil, wicked, or whatever, and she has cut her off from our family. But I'm still the child's conservator. And she would let me see her, and there was some issues. And so a couple of years ago, I did a custody review. And the judge ordered, because this lady, the grandmother, she has tried to have me removed as conservator several times. But it never went through because I do a good job. I have a legal background, and so I know what I'm doing. And her attempts to have me removed has never worked. So during the custody review, she had filed again to try to have me removed as conservator. She wants to be conservator and be in control over the child's money, but she has a felony background, fraud and solicitation or whatever, so she could never be a conservator. But the judge, in order to try to appease like the family thing, he ordered that in order for me to have visitation with my niece, that I should give up conservatorship since it's an issue for her. This is in Superior Court. And so because it was more important for me to build that relationship with my niece, to be able to see her and figure out what's going on with her, I agreed to go ahead and have a county administrator appointed as conservator.
That's fine.
Okay.
So the order went into place. The grandmother still refused to let me see her. And, we tried filing contempt of court, but she avoids service. She hides out, don't answer, whatever. She does everything she can to avoid service. And so I went before Judge Newkirk because they were filing for attorney fees, which they didn't get. And he suggested that I go ahead and uphold my part of the court order and go ahead and file a petition to be removed as conservator. But that was in 2021, and nothing happened until last week when I noticed that there was a freeze put on the bank account. But I hadn't heard anything from probate court in the 2 years from the time I filed in 2021. So now I still haven't been able to see my niece because the grandmother has been just working her against me and refusing to let me see her. She's about to turn 18. But my thing is, I need for her to understand what she's going to be receiving in the way of her funds. her grandmother, so from the time she found out about it, has been trying to get her hands on the money.
I ain't trying to cut you off, but I'm trying to get to that question.
Okay, so the question is,
that a reindeer?
okay, I filed the petition to be removed and the county administrator be appointed, because that's what the court ordered. Can that be rescinded? Can I?
Is this a Fulton County matter?
Yes.
So, I can't speak about open cases. However, either the court is going to act, but the court isn't going to require you to act and file a paperwork. We're either going to rule one way, or you're going to move the litigation forward in the direction that you want. But I can't tell you how to move the litigation forward.
So someone told me that the Superior Court doesn't have any control over what probate court does.
They don't, and simply put, probate doesn't have any jurisdiction over visitation. Right. So they're two separate actions. But just to answer, just you all may be wondering what's going on. There's conservators and there are guardians. So if a guardian can be appointed when someone is no longer able to care for themselves, be it aging, dementia, or they have some other mental issues, and that's where a loved one comes in and says, I want to be in charge of their body. I want to help work on their care, determine where they live. You see this often with aging parents. And then a conservatorship is when someone can't handle their money, and that's just money. So they need someone to oversee and manage their money. So they're two separate things, control of the money and control of the body through a guardianship. And that's part of estate planning as well. Who do you want to care for you when you can no longer care for yourself? You can appoint that person in advance. Otherwise, if you yourself have an aging loved one and you know that they need help and you need to go to the bank for them, you can file in probate court a petition to become their guardian. So, and you've heard about guardianships through Britney Spears and The Blind Side and things like that. So that's what she's talking about, conservatorships over someone's money, but now she wants visitation over the body. Two separate courts, two separate actions.
Right, and so for the existing petition, since that, it's been 2 years, and she's about to turn 18 in a couple of months. It's like, so can I rescind the request because she's getting ready to turn 18? It doesn't seem like a good idea to have an administrator come in at this
Real
point.
quick, I'm not trying to get the judge involved.
Yeah.
You have an attorney represent you?
Well, I do most of them. I work for a law firm, so I do most of this myself. I have
Those are my favorite
Because
people.
I see a conflict.
I used to work for a law firm. I got it.
Oh, okay, but if you can't answer because
It's pending in her law.
I see a conflict, and she already acknowledged there's a situation there, but she separated the difference between guardianship and money. Right. So you want to chime in before?
Yeah, I do, because as the judge brings up that distinction, in my practice and in your practice as real estate agents, we're looking for those conservatorship papers. So when you have that incapacitated adult or that minor that somehow ended up with an interest in real property, and you're dealing with someone that is over their affairs, what I'm going to need to review is the conservatorship paperwork, not the guardianship. Guardianship person, as the judge succinctly said, conservatorship things, property. Right, Nicole?
Correct. And a lot of times I'll get people come in and they're like, well, mom has dementia, for example, and they want to sell the property. They want to, be able to do whatever they want to do with the property. That's not their money. They're really confused about this. This is still mom's money, even though she may not have capacity. And so they have to understand, because sometimes they'll say, well, we were going to inherit the house and now we just want to sell it and get the money now. No, as long as mom is still alive, and even though she doesn't have capacity, she is still the one that is entitled to those funds. And as a conservator, they have to account for those funds. They have to do the reporting and everything to the judge to say what has happened to those funds. Those funds have to be used for her care, have to make sure that she's getting what she needs. And then only after she's passed, or if there are any funds left in the conservatorship, then it transitions to part of her estate. And again, we got to go through that process that we've already talked about, what her estate will need to do.
Now, Coach, this also brings up a matter, guys. A lot of what I'm asked to review powers of attorney a lot, okay? And so there is a Georgia Financial Power of Attorney form. You can find it on the Department of Aging, and that's a general Division of Aging of the state. It's published, it's in the Georgia Code. It works for most transactions. However, our title insurance underwriters do not like that form. They want a specific power of attorney for the transaction. Now, what will happen is people will come to me and say, well, Scott, I got this general financial power of attorney from, it's a Georgia form, and I want to use it to sell real estate. Now, I will run these up the flagpole to our underwriters, and sometimes if it's inconvenient because of illness, because the person can't conveniently execute a new power of attorney, in a rare circumstance, we can record a copy of that general power of attorney if it provides for the power to sell real estate. However, one question I always have to ask, guys, is whether or not they've ever been ruled incapacitated. If Judge Johnson declares an adult, puts conservatorship or guardianship over that person, then they've been declared, an adult has been declared legally incapacitated. That revokes all powers of attorney, and that power of attorney is now revoked. Death also revokes the power of attorney. So people come to me listing properties with these general powers of attorney. Maybe you've even contracted with that general power of attorney. I'm going to have to be the bad guy, and many of y'all have heard this from me. We're going to need a specific power of attorney, and I got to make sure they're not legally incapacitated or dead. I have my paralegals ask that question as well. Make sure they're alive.
Make sure they're alive.
Okay, but that does revoke powers of attorney if Judge Johnson rules that there needs to be an incapacitated adult.
Okay, I have a question.
Yes, ma'am.
One second. No, I got two people ahead of you real quick.
Okay.
I got
One in the
Bernard and then the young
corner.
lady next to Bernard. So go ahead, Bernard.
A quick question and a practical application in real estate. Gentleman owned property here in Georgia for years. Had cancer, got advanced stage. His family came and moved him up north.
We get those.
Okay. Go ahead. My answer formulated.
Finish the talk.
For that family, how do you determine where probate is to be filed?
There's a choice here.
Did he die? He died up there? Okay.
Out of state though, Bernard,
His
right?
name was not Bob.
Now, Bernard, he died in some other state?
Yes.
Okay. All right. The Georgia title standards in the law allows me, if let's say they had some type of probate procedure in that other state, let's just say they did. I can record what's called an exemplified copy of that probate from out of state. And Georgia, under the full faith and credit, we got to take notice of it and use it. So I do scrutinize out of state work, but I have to get my title company involved to make sure that that state, I did one in DC a couple of months ago, and we had to look up my title insurance company had to look up the DC law, because I can't look up law out of other states, and to make sure that we had the power to sell. And I recorded copies of certified copies, exemplified copies of out-of-state probate. So sometimes we can dispense with what's called ancillary probate in Georgia. Sometimes we can't. Now, this is me as the real estate lawyer quarterbacking this as about what we need. Sometimes I have to go send it to Miss Robinson to get probate work done. So if you have out-of-state folks that hold real estate in Georgia, it's going to take some analysis about what is necessary to get that property moved. So Nicola's going to have some choices here. I was able to save these people from talking to their DC lawyer. They did not have to do the ancillary probate in Georgia. We went with the DC paperwork, and they were so thankful. Scott, yeah, great. We didn't have to wait to do the probate in Georgia. But it's a case-by-case basis. But out-of-state folks holding Georgia real estate is real common.
But remember, I said probate can be filed in one of two places: where you lived when you passed away, or where you own real property.
Really, or both.
Oh, yeah.
Yeah.
And so sometimes you want to go through the Georgia full probate process here too, because although they moved him up north, let's say he has some kids down here that nobody knew about. He got this property and he might have had some other family members. And so this is your opportunity to kind of clear everything up, get everything out in the open, and figure out who all of the rightful heirs are to those properties, the ones he had up north and the ones he had in Georgia.
Great question, Bernard.
Great question. Young lady right there.
So I have a client who is the grandson of a deceased person who recently passed. But in her will, she has 5 kids. In her will, she states that they have the executor of the estate, which is the oldest son, which is the uncle of my client. So all the will states is, hey, you're the executor of the estate. Everybody has, all the 5 kids have their own title, whatever their job is for the will. But he has the executor of the estate. So he's not including the other siblings in the process of getting the will probated or selling the property. So they found out, the family found out that he was listing the property without their knowledge. But the will has not, it hasn't been probated yet. So
I wonder if those siblings are heirs. Are the siblings heirs, or do they have children?
Yeah, they're all listed on the will. It's just the will says that, hey, he's the executor of the estate, but these are the 5 heirs, and the money from the house has to be sold, but the money has to be distributed equally amongst the children.
So all 5 children are by law required to have notice. So if he is the executor, he has a responsibility as the executor to make sure that those children are aware of the probate process. And they have their right to come to court and say whether they agree this is the right will, whether it's valid, whatever their objection may or may not be to that will.
Were they notified when he initiated the proceedings?
No.
I wonder if the deceased had children and these are his siblings.
These are his siblings. He's the oldest, but all of them are estranged from him.
Did he have children?
No, he doesn't have kids.
Well, let me tell you what happens when the estranged siblings do find out and they notify the court that my big brother he knew exactly where I was.
Right.
Then the court has to decide, is that really the best person to manage the estate, because they've proven, or at least there's been an allegation that they're not keeping everybody in the loop. And miscommunication or lack of communication breeds mistrust.
Yeah.
And so now I've got some things to think about on who should be in charge.
They can do, and I'm like, well, he's the executor of the estate. You know, he should be keeping y'all informed, because they didn't even know he was selling the property. She didn't even know that it was selling the property, that it was listed.
But the court has the power, when we find out about some tomfoolery, the court has the power to limit the authority of the executor immediately and schedule a hearing.
Okay. But it does have to be probated first before he can sell the property.
For the most part, to sell property, something has to go through probate.
All right, so when you have a testate estate, remember, when there's a will, there are 4 things that I need to review to make sure that we can sell that property. And look, I put my notes down here, but I'll give y'all all a copy. But the title insurance company requires that I review the will, the petition to probate. It must be, there's 2 kinds of probate, guys. There's what's called common form probate and solemn form probate. I'm going to have to require that we have solemn form probate. I have to review the petition, the order admitting the will to probate, and as the judge mentioned, the letters testamentary. The one that people really don't think of is they don't think to let someone review the will before they list, because that executor only has the powers that are put in that will. And there's 2 things you can do with real estate. You can give that executor power to sell that real estate, or you can do what's called a devise. So when you devise real estate, you can actually say, I want that house on Cascade Road to go to Nicola Robinson. And then what does that executor have to do, Judge? They got to give it to Nicola Robinson.
That's it.
That is a specific devise, okay? So don't be listing properties with specific devise. You know when I find this out, gang?
At closing.
Yeah, when it's under contract, we run the title, we come back with a frowny face to the realtors and say, we can't sell it. We got to get a deed out of Nicola Robinson. Who's that? Anyway.
And I just want to share that there are many people who just decide they don't want to go through the probate process and they just live in the house and keep paying the mortgage. Now you're living in a house that is in they don't tell the mortgage company, so all the mortgage company knows is they're getting a check. But when you live in a house that is titled to a deceased person and you haven't gone through the probate process to appropriately transfer ownership of that property, then you're not able to take advantage of certain federal rehab programs. You can't get certain benefits. You can't get a home improvement loan. You can't do anything. So it's what they call dead equity, and you're trapped by it because you can't even sell it. So when you hear about situations where someone is just happy living in a house that is willed that is in a deceased person's name, you want to encourage them to either go through the probate process and make the appropriate transfers, or to look into selling it, because all the tax liens are going to come in the deceased person's name, all the tax bills, everything is going to come in the deceased person's name, and it's going to severely limit the access to enjoy the full experience of that home.
We have Candace here.
Okay, so when we're talking about wills, is it possible for somebody to have a will and file it with your office or somewhere else quietly without telling any of their family? And then if that happens, what does the family do to look for? Where should they be looking?
Sure, that's a great question. So probate court offers a service called Will Filed for Safekeeping. It's $10, and that is where we will take your will that you bring up and we'll hold it for you. And then when you pass away, when your family comes to file and open an estate, we'll go back in the file room, we'll pull the will, and we'll say, this is your family's will. And that's when they'll get a copy. So you can still maintain some privacy. It's not public record until after you pass away. So you can tell your family, if you just choose to keep it private until you pass away, you can say, I filed my will in probate court. It's there waiting for you when you need it.
And if they happen to do that, would you recommend doing that in the county that they live in?
That's the follow-up.
Do that in the county that they're living in?
It's got to be in the county where they own property or
Where they live.
or where they are living. You never know where you're going to be living when you pass away, but at least where they're living in that moment.
Okay.
So
this is getting good. I think
We ain't even talked about leave to sell.
But here's the thing. Did y'all have a presentation y'all was going to present? Because I think y'all having a ton of fun.
Oh yeah,
I had a presentation and we've hit almost all the points. Yes.
The only thing we didn't talk about was leave to sell, because I get these all the time.
Before you go, we're going to still get you rapid fire on the way out. Hit a couple more questions. I'm mindful of the time. We'll hit that rapid fire, giving you a chance to close out any of that thoughts that you might have. I know you're ready to go.
Always.
Now Judge, on an intestate administration, if you ask for the power to sell, don't you have to grant it?
So now we're getting into a document called leave to sell. So say if you pass away without a will, then the court is you get the ability to be the executor, the manager of the estate. Now, you may not have permission to sell the real estate. So at some point, like if it's in your will, this person doesn't have the power to sell real estate, they have to come to the court and request specifically the ability and the right to sell the real estate. And we also have to give notice to all those heirs, and those heirs can still object. I don't want her picking a realtor. I want to pick my neighbor. I want to be in charge of the selling process. I want to get give the final approval. So that's in a contested estate, and we have to have a hearing, and that's when things get more complicated. But you can come to probate court, ask for permission to sell the house, and if there are no objections, you can go. Then the court will grant the ability to sell the house and make the distribution in cash.
How long does it take to get to you?
So I can answer that. Yeah.
I know it takes a while to go to you. How long does it take to get to you? Go ahead.
So, and I'll talk specifically for leave to sell, because I get a lot of realtors that don't understand that process. I tell you, don't ever write that contract for less than 90 days, because I have to find all the heirs. Remember, Judge Johnson just said we have to notify them. Some might be still missing. Some might be elderly. I have one right now. We got 13 heirs. They live all over the country. None of them under the age of 80. It's gonna take a minute. And so I gotta get all of them on the same page. They gotta agree or consent to this sale. They gotta make sure, we gotta send them a copy of the contract. They wanna know how much are they gonna get? Well, what is this other person gonna get? And so all of that has to be lined up, and I have to present and then create the packet that then goes to Judge Johnson for her to review and for them to make sure that the numbers are consistent. So a lot of times we'll see people say, okay, well, I'm trying to sell to a developer or a lender and they didn't want to pay fair market value and all this other stuff. No, all the numbers got to make sense, y'all, because all of 13 of those people are entitled to the most amount that they can get. They maximize the sale of that property.
Now, Nicola, I have a practice tip for you guys, okay? She's submitting that contract for court approval. If you guys amend that contract,
I got to send every last one.
You got to send it to her.
Every single
I have
one.
made it to the table, and amendments have been made post order, and they have to go back to the court. So that is very important for you guys.
And we start that process all over again.
Right.
Because you've made any changes to the contract, guess what? I got to go tell all 13 of those heirs about whatever those changes may have been. And it may be a huge change, like the cost of the property has declined. I had one over the freeze back in December where a pipe burst, and now we got all this mold and all this other stuff. So we weren't able to go to the closing like we had envisioned. Had to start that all over again.
And to answer Coach's question, how long does it take once all the legal work has been taken care of and the notices? We like to get those turned around within 30 to 60 days. However, if you have a sale pending and it's very urgent, that's when you can call the probate court and say, I know Judge Johnson. And then we will prioritize that, but we do that for anyone who indicates that they have a sale pending and they may lose everything, and we certainly give those matters priority to review quickly and give out the approvals quickly.
Can you stop the bank's foreclosure in the process?
We can't stop the bank's foreclosure, but we're happy to provide any documents to the bank to say it's under review, we're close, if you could just hold on a little bit longer.
Now, guys, going back to leave to sell, and I'm glad Nicola was talking about that, because what happens when I'm processing a contract, usually it's intestate administration. And remember, this is when there's no will. Okay? And we want to review documents when you list it, okay? Not when it's already under contract. And on my magical list of things Scott Baker looks at for free, that you'll get when you leave, we want to see three things on an intestate administration. That is the letters of administration, the petition for letters of administration, and the order appointing the personal representative / administrator. Because when you read those things with a trained eye, you can determine what powers Judge Johnson or other probate judge in another county has given that administrator. Sometimes they already have the power to sell without having to hire Ms. Robinson to get it for you. It just depends. People have a folk idea out there listing properties that if they got this, I got the administrator, they gave me their letters of administration.
Nope.
Then once we get a hold of it, hopefully we know this before we run title, but oftentimes the frowny face comes when we pull that probate work on our title examination, and we find out, oh yeah, she is the administrator, but she does not have the power to sell. And then they're like, well, what? Well, you got to get a leave to sell, and that's when we refer people to people like Ms. Robinson to go get it. So a lot of times, unfortunately, in my experience, it's very late in the ballgame. What Nicola said was she needs time. She said 90 days, right?
Minimum.
Okay. So what I'm hoping is you've already seen Nicola by the time I review this paperwork before you list. Now, you don't control these people's lives as listing agents. I know the type A listing agents out here in this room, you want to control their lives, but you don't, okay? But the key is getting that paperwork early and showing it to me or Tajel at my office. Y'all, many of y'all have done this. And so I got this list before you leave. I don't really need to give a presentation because Judge Johnson and Nicola have handled all I know. But I love to look at this stuff before you list it to make sure it's gone through and we can sell.
And all the documents that Attorney Baker is referencing, you can obtain them in Fulton County Probate
All
Court.
public record.
All
guys.
public.
Public record.
We're going to switch it up a little bit. One more question on the floor. Then we're going to give y'all an opportunity to do what we call a rapid fire.
Okay.
Just to get that last little bit of thought out, because if we don't, we'll push past the time. Okay. So.
I just had a question.
No.
Oh,
Okay, my purpose for taking this class is I am involved in a listing as we speak that is having to go through a power of attorney. The person passed, the husband passed, they have 3 properties. The main property is, he died without a will. The main property is for the husband and the wife. They have 2 grown children. The second property is a condo that's owned by the business of the husband and the wife. And the third property is family residence not owned, but the daughter lives in. The son lives in Mississippi, the wife and daughter lives here, and it's total conflict. The son in Mississippi wants to control everything and be his own power of attorney. So my question to you, am I supposed to ask him for a power of attorney? Because the mother lives here and she says she wants to take care of her own business. She wants me to be her realtor. The son wants somebody else. And I'm pulling my hair out.
So wait, you said that the father died, and then you said a power of attorney. Remember, a power of attorney died with him. There is no power of attorney anymore. So if he had a document that may have listed the son or may have listed the wife as the person in charge, that's over now. This is probate time. This is one of them need to go to probate court and file to open his estate. And then through that process, we'll determine who's going to get any of these properties.
So it says that they filed probate, but according to their attorney, whom I've never talked to, never done any documents, says that it's okay to sell the main home that the mother and father own because all the 100% of probably goes to her.
Joint tenants.
They were joint tenants with the right of survivorship.
Yes.
So then, yes, if it was joint tenants, then it would, remember, they're 100% owners, 100 to him, 100 to her. His 100 is kind of absorbed into hers when he dies. So yes, she can legally sell that property. If the other properties are either in his business name or in his name with her as tenants in common, they're going to have to go through probate.
So he says that they're in probate, but am I supposed to get something from him?
Yeah.
Oh, yeah.
You want to see the will?
Yeah, we got a lot of stuff.
Copy of the will, the petition.
Every day, it's like he is taking full control. He's even got another relative.
So he's a nobody right now.
But again, you said that he is filed in probate. So what county is it? Go to that county, find what's been filed. It's all public.
Because I don't have anything. Yeah, he lives in Mississippi.
And just to be clear, a power of attorney is where I give someone the authority to be me. I can do a general power of attorney, which says he can do everything that I can do, or I can give someone a limited power of attorney. You can only sell my car, you can only take care of my children, you can only do what have you. So it always pays to read the will and read the power of attorney, because the power of attorney tells you what you can and cannot do. And you don't, as long as you're alive, you don't need a power of attorney for yourself because you're making your own decisions, only when you're empowering someone else. So if mom doesn't want to give the son the power of attorney, as in she doesn't want him to represent her and she wants to make her own decisions, she has the right to do so, unless he goes and gets a guardianship against her and sort of takes away her decision-making ability. But as it stands, if she can make her own decisions, she can and she will and she should.
He says
Don't worry
she's
about
not
it.
mentally capable.
She's following up. Son got a lot to say.
1 second, I got one more question and I got to go rapid fire. The question's over here. I see you, Rebecca. Go ahead, real quick.
Okay, because we have attorneys in the room and the judge, but what about those folks who are going and filing without an attorney? What are some of the top mistakes that people made?
That's a great question.
So that we're trying to help
Always
our
put mine in
clients
airplane
who are
mode because that's the only way I
trying to
can
do
guarantee it's not
something
going to
that's
ring.
Really, I ideally want to point them toward an attorney, but top reasons why?
About 50%, we do about 4,000 estates a year, and about 50% of those are filed by pro se litigants, families representing themselves. And one of the big misconceptions is, number one, the entire probate process. What are we doing here? The court is simply giving and selecting one person to be the authority to dispense the estate according to law or according to the will. So just because this person is in charge doesn't mean they can take everything. They just are the person who's managing the estate, but they still have to account to all the others. So we get a lot of objections. Oh no, I don't want her to be in charge because she's going to take everything. And that's a valid objection, but it hasn't happened until it's happened. So, you know, it's sort of, you can object, and that creates a lawsuit and that creates a court dates, but to be clear as to what you're objecting to. I don't want this person to be, I'm either contesting the will or I'm contesting who's in charge. Those are the two things.
And there are a lot of people who call me because they don't want to pay me. I understand. But we're talking about people who don't have.
We're going to talk about pay. We're going to go rapid fire because we need to know how much it costs to hire you.
No, I want to address her question first. A lot of times people don't know what they don't know. And so when they go into probate, they're thinking, oh, it's just a bunch of forms. I can get them online, send them to the judge, easy peasy.
The freebie way.
The freebie way.
Okay.
And then they get in there and then they have these other family members pop up. Then they have these people who are contesting it. And then they have now created this spot. And Barbara, you could talk about this. They have created this monstrosity of things because they don't understand like how the numbers need to line up and how everything needs to work together. Barbara actually came to my office. Can I tell them? Sure. Okay. Barbara came to my office with a client of hers because she tried to do the probate herself. And she came in with all these papers, bless her heart. And I was like, okay. She was like, well, I'm ready to close. I've done all the work. I've done the probate stuff. And I didn't even have to read most of it. I could already tell. Everything didn't match up. She didn't do all the steps because most lay people don't know what all the steps are. They don't understand who needs to be put on notice, what creditors need to be paid off. If you put on that petition that there was a house for $200,000 in the estate, at the end, we're going to ask, well, what happened to the house? Or what happened to the money from the sale of the house? So all of this stuff has to match up. And a lot of times people don't understand that. So just be mindful when you have people who are saying, oh, I'm going to do the probate myself. Tell them, good luck, God bless. Now, as far as my fee.
Now, it don't have to be your fee, but in general, the basic cost would probably round about.
So it again, like everything else, it depends. All the lawyers, we can set our own fees. My fees look very different from Scott fees. We all do our fees differently. I do my probate cases in stages because sometimes the family just needs me to open the estate. I get a lot of probate cases where maybe there was a personal injury settlement and they can't finish up that lawsuit until the estate is open. But they have a savvy family member or it's only one heir and there's not a lot of other assets that's in there. So I'll do just the first part of the estate for $3,500. Then if they want me to complete the entire probate process, it's usually $6,500. And that is, we do all the publications, we make sure those IRS taxes are taken care of, we make sure all of...
We're going to do it all. We're going to do the rapid fire. Boy, I got to get to the rapid fire. I'm going to give y'all the microphone.
You're going to give us
okay. I got to give them the microphone because all this information is good, but I don't want to run over because I know you got to go somewhere, your time is important. And I know the cost is the cost. Right?
The cost is the cost.
And that's the cost. But me and all my siblings, we got to come up with $6,000.
But no. So sometimes if there's money in the estate, sometimes you only need to come up with the initial cost because my fees can be paid from money that's in the estate.
Correct.
I pay probate lawyers at closing all the time.
Keep your receipts because if you pay for a lawyer, that can be an expense of the estate. And I also want to share with you that in Georgia law, funeral expenses take priority over everything.
So all of that
So if you put in on someone's funeral, when the estate begins to be liquidated, you can present your receipts and you are first to be reimbursed for those funeral expenses.
So here's rapid fire. Rapid fire, we're going to give everyone 3 minutes, uninterrupted. to talk about anything you want to talk about. So if you had those things that you want to close,
I think we covered a lot.
Now they don't know what. So we started with you. We ended with you. So let's start with Scott. Scott,
Okay,
we'll
guys,
start with you
guys.
first.
Get those deceased estates looked at before you list the property. I have my list of information I review. Things we didn't get to. I do need to read trust agreements when your seller is a trust. The title insurance company makes me do it. I'll review those when you list. There are oddball things that we didn't get to as a team. Things like award of year support, no administration necessary orders. These are the types of documents that I will ask when we talk before you list a property, when you have a deceased estate, a trust, an incapacitated adult. Anything that would go through Judge Johnson's office, I will look at it before you list it because it saves me grief when I do work preparing a file for closing that's not going to close. And then I will oftentimes, since I'm not a probate lawyer, I'll send you to one of Ms. Robinson or one of her colleagues. Look, if someone's going to charge me what I think is a reasonable fee, I always recommend the professional help. People insist on doing this by themselves. That's what happens. But from where I sit and doing it for 25 years, you have a much better likelihood of success in getting that property sold with professional help than you do without. So that is my recommendation. And I refer lawyers to people. And they're like, oh, that's a lot of money. Well, I gotta tell you, I do collect these fees at closing. If there's an asset there and there's real estate, there's usually a way. You just gotta work it out with that probate lawyer. So I recommend professional help. I recommend getting the free listing advice from me. I don't give legal advice to your clients. I give legal advice to you because I'm helping you with your business getting the property listed, okay? So I will look at paperwork to help you. That's what we do. And I know half the room has used me for that. All right, that's my 3 minutes, Oliver?
That's 3 minutes.
All right, Coach.
Let's give a round of applause, y'all.
Oh, guys, before I leave this, I'm going to leave this list. This is a list of documents that I commonly review, and 2 lists of things that my title insurance company requires that I receive when we sell estates, and I have it all. That's the important thing. Okay. Thank you, Coach.
Now, you would think I'm gonna go to the judge, but I'm old military, so rank has its privileges. So we're gonna go ahead and let Nicola go ahead and we'll let the judge close us out.
I feel like we have pretty much summed it all up. So I don't know that I have too much more to add. I think Scott did a great job. Outside of just doing a lot of asking questions on the front end, guys, before you guys get, overzealous, want to list this property, ready to, get your commission and bid this family adieu. Find out as much as you can about the people who are listed on that deed. The deed, again, that's the heavy lifting sometimes, is getting a hold of that deed and figuring out who those people are. And if it's one of them is dead, red flag. That's the first place you want to say, okay, well, tell me more about this person. Did you do probate? Did this person, were they married? Did they have some kids? Like, start asking those questions, because that's going to help you to figure out, is it realistic that we can sell this property in 90 days? Or is this going to require an entire probate that could be 6 months to a year, depending on how many heirs are involved, how complex it can be. But that will help you guys save yourselves a lot of headache and heartache, because it does break my heart when I have to tell those agents, oh, we're not going to get to the closing for a while. And they're like, no, but we're ready to sell. We're ready to close. We got a buyer who's moving from out of state, and this is their dream home. What can you do? Nothing. I got to do what I got to do. I got to do what the law requires, and then I got to send it to Judge Johnson and her team for them to review. So it takes a while. So just have all of that, as much of that on the front end, and know that going into the transaction will help and save yourselves a lot of heartache. That's it.
I want to ask one follow-up real quick. So for real estate professionals, do you recommend a one and done or to niche this business process?
Oh, that's a good
Short
question. My answer is always it depends. So it's hard to.
One and done or bitching?
It always depends.
Yes.
I mean, so it always depends on the circumstance.
Yeah.
And so it's hard to say, just chunk it down and get, look, I would make it a case by case basis. You just gotta, look, my thing is, if I'm the family, because this is the family, maybe not you, I would sit down and pay a little bit of money to get a consultation and then come up with a path before you list the property. Now, you're coming into this after they've already made the decision. Let's sell, right? Nicola, what do you think?
Yeah, no, I agree with you 100%. Spend just a few dollars. My consultation fee is $350 on the front end. Come, sit down, have a conversation with the family. I can start asking them those questions, and then we can figure out, does this make sense?
Now, Nicola, I'm thinking you're looking at their documentation that they already have. You're getting the family history. All that when you just the initial consultation.
Yeah.
You already have.
You see how they consult with each other?
Mm-hmm.
But at the end of the day, we got to go to the Your Honor. Honorable Judge, Senior Judge, Probate County, take us home.
I want to use my final 3 minutes to speak to you personally and professionally. I get it. We're talking about estate planning, but death is an uncomfortable conversation, and no one wants to think about when and how they will leave. But just understand that for your family, it offers them a measure of support if they have the mission of carrying out your wishes. Everyone is clear. Mama wanted her ashes scattered in the country or in the streets of Paris. Whatever it is that you want, having an estate plan can guarantee that your legacy, your life's work, your hard work is being carried out. So think about the right time to have this conversation with your family. Maybe it's not after Thanksgiving dinner and the drinks have been flowing, but at some point, get the family together, figure out what you want to do, what you want for them, and spread the word. And what I want to speak to you professionally about is we did mention a pro tip called years support. Yeah. So remember I mentioned that Georgia law favors spouses, taking care of your spouse? Well, there is a little known carve out in the law that says that a spouse, no matter what the will says, no matter how many other children are involved, the law states that where a spouse, the spouse can quantify what 2 years of her deceased spouse's contributions would have been. And she can ask the court to carve that piece out for her before anybody gets a dollar. So if the husband was the breadwinner, he passes away. Now what am I going to do? I was a homemaker for 20 years. How am I going to pay the bills? So I can say he would have paid the mortgage and he would have done this. He's got this money over here. I need to ask the court for $100,000 first. And with that year support, the court is required, unless we hear a good reason not to carve out that piece for the continued support of that surviving spouse. And many times that's the whole property. So if they have a residential house but it belongs to, or he may have willed it to his children, that may not have been your children, or willed it to your own children, but the wife still needs a place to live, she can actually take it from the children. So it's called year support, and it's a way that many people use to usurp the probate process. If it's just one piece of property, instead of fighting with the kids over percentages of the property, I can file a year support and may wind up getting the whole property deeded just to me. Something to think about if you have a family member who wants to sell and others who don't want to sell. That's a way, that's a tool in Georgia law that is available to you all. Fulton County Probate Court is here to serve you all. Ask questions, engage in estate planning, let us know how we can help you. And we appreciate being connected with the community. If there are other opportunities for us to share about the probate process, call and let us know. We've got staff members or myself. We'll come out and we'll talk more about the probate process.
You got one of these out there, right?
All right.
These are out here. If you got a copy of them. Bring Barbara up real quick.
Probate court also handles weddings. We also handle weapons carry licenses. Georgia is an open carry state, so you don't have to have a weapons carry license to have a firearm. However, if you want to travel with your weapon and go to another state, then you can, with your weapons carry license, you can enjoy reciprocity in other states. We also handle guardianships and conservatorships, so call us when you need us.
Let's give a round of applause. I tell you, on behalf of Better Homes and Garden Real Estate Metro Brokers and the leadership, owner Kevin Levant, staff and directors, first of all, I want to say thank you, Barbara Lancer, the team leader here. Let's give a round of applause. Office manager back there, let's give a round of applause. Again, let's go ahead and give Attorney Robinson a round of applause. Attorney Scott a round of applause. And Attorney Johnson a round of applause. Give yourself a round of applause. Thank you so very much. I'm turning it over to Barbara. Let us close this out.